First of all, I would like to join the other speakers in giving due thanks and congratulations to Jordi Ferrer, Carmen, the University of Girona, and Marcial Pons for a wonderful Congress and their kind hospitality. And secondly, say that it is a great honor for me and pleasure to present Professor Will Waluchow of McMaster University, who will be speaking on the neutrality of charter reasoning. Professor Waluchow's work is very well known by most of you, but let me just mention several of his publications that have been of the most importance and influential within the jurisprudence community. Of course, his book on inclusive legal positivism, a book that has been translated into Spanish precisely by Marcial Pons, his important articles on the nature of law and adjudication and legal positivism. For example, these come to my mind immediately: The Many Faces of Legal Positivism and Authority and the Practical Difference thesis in defense of inclusive legal positivism. And also his latest contribution, published as A Common Law Theory of Judicial Review, published in 2007, a book that is also translated and published by Marcial Pons in 2009. This book has stimulated important comments in law journals and book reviews, and that has prompted Professor Waluchow to reply to several of his critics. This talk addresses one of the issues raised in the debate, precisely the neutrality in charter reasoning. So without further ado, again, it is a great honor to present a very good friend, Will Waluchow.
Well, thank you, Juan, for your very kind introduction. It's a pleasure to have him here as my chairperson. As Juan mentioned, there are a lot of people to whom thanks should be extended here, and those include, of course, Jordi Ferrer and his team. I'd like to thank also the University of Girona, Marcial Pons, and the many other sponsors of this wonderful, wonderful conference for bringing us together in this absolutely splendid forum and for providing me with the opportunity to participate. I'd also like to thank you all for coming to this talk, particularly after a wonderful lunch with lots and lots of wine, and I think most of you would rather be home sleeping right now than listening to me drone on, and so I thank you profoundly for your willingness to come and listen. And finally, I'd like to extend my deepest thanks to Marcial Pons, to Jordi Ferrer and Professor Amoreso for including my books in their Law and Philosophy series, and thereby providing me with a wonderful opportunity to bring some of my work to the attention of the Spanish-speaking world, and so I'm very, very grateful for that opportunity. What I'm going to do is read an abridged version of the paper that was submitted and which was posted on the website and which you all have. It's going to stick pretty close to that text, but it'll be a seriously abridged version for purposes of time. Judicial review under a Charter of Rights, and I'm going to call that charter review, is not an easy practice to justify in a liberal democracy, particularly one marked by what is called the fact of reasonable pluralism. It appears to be an unavoidable feature of modern democracies that reasonable people of goodwill and integrity, faced with what John Rawls calls the burdens of judgment, will continue to disagree fundamentally about moral and political matters, even after what looks like an exhaustive good faith investigation of all the relevant reasons and arguments. Even if there is a truth of the matter with respect to the important questions of political morality that concern us in liberal democracies, to a very large extent, it seems, that truth is epistemically inaccessible to us. And if it's epistemically inaccessible to us, we seem to have no way of discovering which among the various reasonable answers often offered to the questions posed are correct or most justified, or whatever one's preferred description. This is particularly so when we reach the level of what are called comprehensive moral and religious doctrines, where deep differences emerge between Kantians, utilitarians, Christians and Muslims, atheists and theists, and so on. Now, despite this predicament, we more often than not need to settle on a set of answers, some way of, as Rawls put it, formulating our plans, of putting our ends in an order of priority, and making our decisions accordingly. Now, one of the claims virtues of ordinary majoritarian democratic procedures is that they're intended to facilitate shared settlements on these questions, and do so in a manner that appears prima facie fair to all who have a stake in the relevant matter. One person, one vote, it's said, ensures that each participant in this process participates on an equal footing and has an equal chance of having her admittedly controversial answer carry the day. It also ensures that the answer chosen can be legitimately described as our decision, not the decision of whatever faction happens to have had enough power or influence to win the day. Majority voting procedures allow us, all of us, it's said, to take ownership of the laws that regulate our lives and restrict our liberties, even those with which we fundamentally disagree. In short, it seems to respect our autonomy. But things seem quite different when charter review enters the picture, judicial review under a Bill of Rights or a Charter of Rights. It seems to add a new element to our decision-making process, one that seems seriously to disrupt the path to ownership and legitimacy I just described. And that's because, arguably, charter review takes away citizens' power of decision and authorizes judges to make controversial moral and political decisions instead. According to its most forceful critics, and I have particularly in mind here Jeremy Waldron, charter review enables judges to impose their own partisan moral views on the rest of us, citizen and legislator alike, whether or not we agree with those views, and whether or not we've had a fair opportunity to influence, let alone contribute to, the decisions the judges end up imposing. Now, given the fact of reasonable pluralism, many of us will, of course, inevitably disagree, sometimes profoundly so, with the moral bases upon which the judge's decisions are made in such cases. Sometimes, of course, that disagreement will be ill-founded, maybe even unreasonable. It's yet another feature of modern liberal democracies that the moral and political views of ordinary citizens and even their elected representatives are sometimes uninformed, irrational, or perhaps unduly motivated by factors like fear, unmitigated partisanship, selfishness, prejudice, and so on. In at least some such instances, especially when someone's fundamental moral rights are being threatened by a democratic process seemingly gone astray, a somewhat plausible case can be made that allowing judicial decisions to help settle matters might not be such a bad thing to have, even within a liberal democracy. Perhaps judges are able, in such circumstances, to, in a way, save us from ourselves, to make the decisions that we would have made had we not been subject to the various improper influences we seem unable fully to avoid or suppress. That's quite often the standard justification of judicial review under a charter. Perhaps, in other words, charter review can serve to enhance, not reduce or eliminate, our moral autonomy. But quite often our disagreements can't be so readily dismissed. On the contrary, they seem perfectly reasonable. But if that's true, then how can one possibly meet the burden of justifying a practice like charter review in such cases? How can we possibly take ownership of the decisions reached through such a process and of the significant legal consequences that often follow from them? Now, in previous work, particularly the book that Juan mentioned that's in the Martial Pons series, I tried to meet the rather hefty burden of answering those questions. I argued for a conception of charter review under which The principal role of the judge is not to adjudicate on the basis of his or her own moral convictions in regard to the issues of political morality, such as equality, fundamental justice, the right to life, liberty, and security of the person, but to hold the community to its own fundamental moral commitments on those kinds of matters. These commitments, I suggested, are expressed or represented in what I called the community's constitutional morality, or henceforth I'm going to call that CCM. As I conceive it, CCM is not the personal morality of any particular person or institution, for example, the Catholic Church, the Republican Party, or a judge who helps to decide a constitutional case. Nor is it the morality decreed by God, inherent in the fabric of the universe, or residing in Plato's world of forms. Rather, it's a kind of community-based positive morality, consisting of the fundamental moral norms and convictions to which the community has actually committed itself, and which have, in one way or another, acquired some kind of formal legal recognition. Okay, thanks. It's the political morality actually embedded in or endorsed or expressed by a community's constitutional practices, in much the same way, perhaps, as particularized principles of corrective justice may be embedded in or endorsed or expressed by the tort law of Anglo-American legal systems. So construed, CCM might be thought of as a subset of the wider set of moral norms, which enjoy some not insignificant measure of considered support within the community. However that's identified, and the question of how you identify the community is, of course, an important one, but I don't want to get into that today. Some members of this wider set lack any kind of legal recognition whatsoever, even if there are within the community moralities of some contemporary Western societies norms of positive morality governing non-political matters like friendship, gratitude, maybe marital fidelity, charitable giving, as well as norms governing political matters like the responsible but legally unregulated exercise of political power. These are not, in the main, part of the CCM of those societies because they lack the appropriate legal recognition. Distinct, different principles of equality and fundamental justice are, on the other hand, characteristic elements of the CCMs of those communities. In the United States and Canada, to cite two examples, and in many countries of the European Union, legal recognition of CCM norms includes, though it's not limited to, enshrinement in a bill or a charter of rights, and the legislative history and jurisprudence that combine to flesh out the local concrete understandings or Thomistic determinations or specifications of those principles for that particular community. And with that particular conception of constitutional morality in hand, I set out to defend charter review against many of its forceful critics, particularly those like Jeremy Waldron, who view the practice as fundamentally at odds with democratic principle. Put simply, my argument was that CCM, owing to its social origin, is a source of moral norms upon which judges can legitimately draw in charter review without compromising democratic legitimacy. Now, a key premise in my defense of that thesis was the claim that charter review includes, though it's by no means limited to, the task of ensuring that acts of Parliament or Congress do not, in ways that might not have been foreseen by legislators, infringe the fundamental norms of CCM. Now, if that's the role of a judge, that a judge plays in a particular case of charter review, then I argued that democratic legitimacy is not really compromised. The judge is, in effect, helping to implement and render effective the democratic will by holding the community to its most fundamental moral commitments. Furthermore, many of the critics' other concerns can be successfully parried as well. For example, one prominent complaint is that charter review foolishly asks judges to serve as philosopher kings and queens, ask them to discover an elusive Platonic moral truth in respect of matters of justice and equality, and to enforce their understanding or interpretation of that elusive truth against the acts and erroneous interpretations of our democratically elected legislators. Now, given the fact of reasonable pluralism, together with the fact that judges, no less so than the rest of us, suffer from Rawlsian burdens of judgment in matters moral, having them perform such a task asks judges to accomplish the impossible. Not only that, it seems to transform the judicial task into something completely different from the role judges have traditionally been thought to play, by most everyone except perhaps certain fundamental skeptics about legal practice. It's to give up even the pretense of supposing that in charter cases, or cases under bills of rights, the role of a judge is to engage, or at the very least make a good faith attempt to engage, in the impartial, neutral application of binding legal standards largely set elsewhere. That is, to play the role she's supposed to play in everyday run-of-the-mill legal cases. Instead, it's to ask judges to decide on the basis of what ends up being their own, possibly purely partisan, moral opinions about an elusive Platonic morality. And no matter the high regard in which we might hold our judges, such a practice, it seems, can't be tolerated in a liberal democracy. But if I'm right that judges in exercising charter review are not seeking and inevitably failing to apply this elusive Platonic moral truth, but are instead seeking to hold the democratic community to its own constitutionally grounded moral commitments, and if, in addition to this, I'm correct in thinking that that set of commitments can often be discovered through a kind of morally neutral, impartial reasoning, then the sting of that powerful argument can be largely avoided. We can restore the possibility of judicial impartiality and neutrality, a possibility which seems central to the legitimacy of legal decision-making within a democracy. Judges are not, on this view that I've defended, being asked to decide on the basis of their own best judgment concerning the demands of moral truth. Rather, they're being asked to decide on the basis of their best judgment as to the democratic community's best judgments concerning the demands of moral truth. Marks an important difference, I think. Judges can be said in such circumstances to be doing nothing more contentious than doing their best to apply in a fair, impartial, and neutral manner standards that originate from an entirely legitimate source, namely the community's own fundamental moral commitments. Now, if matters were only that straightforward, but of course they're not. As some of my critics, Juan mentioned them, have pointed out, we seem reasonably to disagree not only about the demands of Platonic moral truth. There's considerable room for disagreement about the demands of CCM as well, especially in legal cases in which disputes about its concrete requirements come fully to the fore. Of course, the sheer fact of disagreement does not in itself imply that there's no fact to the matter in such cases, and that CCM is therefore incomplete or indeterminate, and hence unavailable to a court as a ground for its decisions. This no more follows than it follows that there are no determinate answers available when there's reasonable disagreement about the nature of black holes, or about whether the defendant exercised reasonable care to ensure the integrity of his neighbor's property when he set about chopping down the defendant's tree. But there's no getting around the fact that such disagreement threatens to undermine the practical possibility of neutral decision-making, and hence legitimacy, unbiased neutral decision-making by judges. How can the decision to apply a CC norm in a particular case be properly described as impartial or neutral if there's so much partisan disagreement about its proper understanding or interpretation? The question naturally arises, will judges in the end be forced to base their choices on their own personal views about Platonic moral truth? What else could they do in those circumstances? short of simply deciding to make no decision at all. Now, once again, in previous work, I've argued that things are not quite as bleak as might appear at first blush for defenders of charter review in the face of reasonable pluralism. In a good many CCM cases, I think there's much more of a basis for underlying agreement and consensus than initially meets the eye. In other words, the limits of justified charter review don't extend only so far as we find explicit agreement in the community. Now, it was here that drawing on the notion of reflective equilibrium, most closely associated with the political philosophy of John Rawls, but not exclusively, of course, I argued that our considered judgments concerning our CCM commitments can often be brought into reflective equilibrium with one another. When that happens, I argued, we can be led to see that we actually agree, or are committed to agreeing, if one prefers that way of phrasing the point, on more than we think we do. We can, in other words, be led to recognize an implicit basis for explicit agreement on the meaning and implications of the relevant CCM norms, when initially this might not have seemed possible. I argued that the judge's role in a charter case, enforcement of the commitments of CCM, will often lead her to draw on these bases of agreement and to decide accordingly. When such a basis is found and a decision is made on its footing, the fact of disagreement will sometimes be replaced by reasonable agreement, at least widespread reasonable agreement. And that was the case, I suggested in those writings, with respect to the question of same-sex marriage in Canada. Despite all this, there's no getting around this further point. It's distinctly possible that in some cases arising under what I call CCM, especially those in which controversy runs deepest and where differences are rooted in significantly different comprehensive doctrines, maybe there's no uniquely answer to be found, just answers. And what, one might reasonably ask, are judges to do if they encounter a case in which they're firmly convinced that that's so? Well, in my view, judges should, and in fact, at least in Canada often do, engage in a type of moral reasoning traditionally associated with the common law. They should creatively develop the norms of CCM in an incremental, case-by-case way, in much the same manner as common law judges have historically developed, incrementally and in a case-by-case manner, principles of negligence, the concepts of foreseeability and the reasonable use of force, and so on. In so doing, I suggested, they often engage in Thomistic determinations of common notions, to use that phrase that Aquinas uses. Deciding among available solutions, none of which is uniquely determined by, but each of which is consistent with the relevant moral notion, and with previous efforts to shape it through previous processes, previous instances of the process of determination. Such previous attempts we might think of as having set CCM precedents. Judges will, in many such cases, end up exercising discretion to choose from among non-excluded solutions, but, and this is an argument I make in the book, there is, in my view, no better way to proceed in these circumstances. Now, if we acknowledge that the process of determination is indeed what should be, and perhaps is, going on in some of these cases, then we once again encounter our threat to democratic legitimacy. The threat and the reason we face it again should be fairly obvious by now. In developing CCM in this way, judges can no longer be straightforwardly viewed as attempting to follow, in an impartial, fair, and neutral manner, standards previously set by others with the democratic authority to do so. And on the contrary, it will be they who will themselves be setting the relevant standards. At the very least, they'll be deciding what authoritatively established standards shall be taken to mean and imply for the particular kind of situation in which the relevant charter question has arisen. In short, they'll be involved in the creation, not the discovery and application of law. To put it in terms more familiar to constitutional lawyers, they'll be engaged in construction, not interpretation and application. So, admitting what appears pretty certain, that the norms of CCM are not always fully determinate, threatens to reintroduce the original concern. That charter review can't possibly be justified in a democracy. It appears to assign judges a role, the construction of CCM norms, and from now on I'm going to use that word construction, that renders us no longer masters in our own houses. We can no longer maintain ownership of all the laws that regulate our lives and restrict our liberties. Handing over such a significant power can't be justified on the usual ground, that judges are simply applying in a more or less neutral and impartial manner standards authoritatively set through one or more of the democratic procedures we encounter in liberal democracies. Now, of course, we must never lose sight of the fact that even in run-of-the-mill cases, not involving the construction of CCM norms, judges do not always succeed in displaying, to an acceptable degree, these same judicial virtues of fairness, impartiality, neutrality, and so on. And in such cases, the usual justification won't be available either. But in all such cases, there's at least the theoretical possibility that the judges will succeed in displaying the required virtues. And we at least have an intelligible basis for criticism and complaint when that possibility isn't actualized. When the judge's decision, in a particular judicial decision. But nothing remotely like that seems available when the judge's decision requires her to develop or construct the relevant elements of CCM using her discretion. There simply is no such justification and no such basis for assessment and critique on those terms. Now, if despite what I've just conceded here, we continue to ask judges to make the kinds of discretionary determinations that sometimes seem necessary when CCM is in play, then we appear left with two options. First, we can abandon all pretense of reconciling charter review with the demands of democratic legitimacy, Waldron's preferred option. In other words, we can reject the practice altogether, or attempt to justify it by way of competing values, for example, justice, or values most closely associated with the rule of law, but just give up on the idea of trying to make it compatible with democracy. Alternatively, we could develop a more nuanced account of what it is that judges should be up to when they engage in these discretionary constructions of CCM by way of common law reasoning, as I've suggested in the book. Now, it's that latter option that I want to pursue in the remainder of my paper. So my question is this: is there a way of engaging the process of CCM construction through a kind of case-by-case reasoning modeled on the common law and its methodology that still allows for the possibility of impartial, neutral decision-making by judges? If there is, then perhaps we've got a way of reconciling discretionary charter review with liberal democratic principle. We may yet be able to maintain ownership of all the laws and legal decisions that regulate our lives and restrict our liberties, even those discretionary decisions with which we fundamentally disagree. To see them is, in a very important sense, our decisions, not those of the judges. So, how could this be done? Well, I'd like to suggest in this paper, I'm trying out this idea here, that discretionary constructions of CCM can be rendered consistent with democracy if we place significant restrictions on the kinds of reasons upon which judges may legitimately draw when they engage that process, and the kinds of reasoning that they have to adopt. Now, the restrictions I have in mind are inspired by the theory of public reasons developed in a number of places by, principally, but not exclusively, John Rawls, most notably in Lecture 6 of Political Liberalism. Now, were we to restrict judges to Rawlsian public reasons, or Rawlsian public reasoning, we might have a way of rendering discretionary developments of CCM, constructions of CCM, consistent with the fundamental principles of liberal democracy. So, what are these public reasons and public reasoning? According to Rawls, public and non-public reason can be distinguished from one another in terms of a number of key features. I'll just list some of them. First, quoting him, "The limits imposed by public reason don't apply to all political questions, but only to those involving what Rawls calls constitutional essentials and questions of basic justice. Thus, questions concerning, say, the scope of free expression fall properly within the domain of public reason. Questions concerning the most efficient means of assuring a competitive auto industry mostly don't." What precisely Rawls means by constitutional essentials and questions of basic justice perhaps is not altogether clear. But however that issue is resolved, the resolution will surely be such as to subsume under the domain of public reason the kinds of morally charged fundamental questions with which courts are typically concerned when they engage in judicial review under a charter or Bill of Rights. These include questions like the coercive regulation of hate speech, pornography, campaign financing, the banning or regulation of abortion and euthanasia, the right of child soldiers incarcerated in foreign detention facilities and subjected to torture and interrogations that flagrantly flout constitutional principles, to the protection and assistance of their government. Canada has such a case at the moment. If these are not concerned with constitutional essentials and issues of basic justice, it's hard to imagine what might be. A second key feature of public reason for Rawls is that it's what he calls the common reason of a liberal democratic society. Quoting him, "It's a way of formulating its plans, of putting its ends in an order of priority, and of making its decisions accordingly." It, again quoting him, is characteristic of a democratic people. It's the reason of its citizens, of those sharing the status of equal citizenship. The subject of their reason is the good of the public. Now, non-public reasons, on the other hand, include the reasons of churches and universities and of many other associations in civil society. They include the highly contentious moral and political premises characteristically found within various comprehensive doctrines. These might legitimately be appealed to by private citizens in discussions pertaining exclusively to their private affairs and the affairs of the various private institutions and associations to which they belong. That it has been so decreed by the Pope is a legitimate non-public reason for Catholics, perhaps, when debating some contentious matter of Catholic theology, even those bearing on questions of political justice. For example, the morality of abortion or euthanasia. It's not, however, a public reason to which citizens, in Rawls' view, can legitimately appeal, quoting him again, when they engage in political advocacy in the public forum, and thus for members of political parties and for candidates in their campaigns and for other groups who support them. As Rawls stresses, citizens often engage in decidedly political dialogue outside of public forums, hence they're not always restricted to public reasons when conversing about political questions broadly construed, including those pertaining to constitutional essentials and questions of basic justice. Not so public officials, however. Whenever they are acting as officials, a complete ban on appeal to non-public reason applies, in Rawls's view. It applies in official forums, and so to legislators when they speak on the floor of Parliament, and so to the executive in its public acts and pronouncements. Most importantly for our purposes, perhaps, quoting him again, it applies also in a special way to the judiciary, and above all to the Supreme Court in a constitutional democracy with judicial review. That's because the justices have to explain and justify their decisions, he says, as based on their understanding of the Constitution and relevant statutes and precedents. Since acts of the legislative and the executive need not be justified in this way, the court's special role makes it the exemplar, he says, of public reason. Now, it's worth stressing that for Rawls and others who draw a similar distinction, public and non-public reason do overlap with one another in significant ways. Often it's hard to distinguish the two. Both include, for example, elementary rules of inference, and agreed rules governing the evaluation of evidence. What principally distinguishes the two domains in this regard is that public reason is restricted to premises enjoying widespread support within the community. These include, quoting him, presently accepted general beliefs and the methods and conclusions of science, when those are not controversial. But crucially, they also include what Rawls calls, famously, a political conception of justice. That's a shared conception of justice on which all reasonable people within a particular liberal democratic society, regardless of their other deep differences, could reasonably be expected to agree as a common basis upon which to conduct public life. It's a conception which each person, from the vantage point of his or her own partisan, comprehensive conception, could accept as a reasonable basis upon which the coercive power of the state is to be exercised on her behalf, and that of her fellow free and equal citizens. Now, as Rawls stresses, there's no uniquely justified or most justified political conception of justice. They can vary from one society to the next and from time to time. More importantly, though a particular conception might be acceptable to each person as a reasonable basis upon which political power is to be exercised, it almost invariably demands some degree of compromise from everyone. Different citizens with differing comprehensive doctrines will almost always prefer the political conception closest to the one judged ideal from the vantage point of their own comprehensive doctrine. But each person, recognizing the fact of reasonable pluralism, will also realize that garnering the benefits of civil society almost inevitably requires that everyone has to settle for less than their ideal choice. Each will also acknowledge the requirement that an acceptable compromise from her vantage point must also be, for no doubt different reasons, and perhaps to a greater or lesser degree, an acceptable compromise for other people whose comprehensive doctrines suggest maybe a quite different order of preference. Now, that Rawls claims is a requirement of what he calls the duty of civility, a duty recognized in all reasonable comprehensive doctrines within a liberal democracy, one which serves as the basis for agreement on a shared political conception. Now, Rawls nicely summarizes this crucial feature of public reason and its appeal as an ideal for social deliberation within a liberal democracy in the following words. The ideal expresses, he says, a willingness to listen to what others have to say, and being ready to accept reasonable accommodations or alterations in one's own view. Public reason further asks us that the balance of those values we hold to be reasonable in a particular case is a balance we sincerely think can be seen to be reasonable by others. Or failing this, we think the balance can seem at least not unreasonable in this sense, that those who oppose it can nevertheless understand how reasonable persons can affirm it. This preserves, he says, the ties of civic friendship and is consistent with the duty of civility. On some questions, he says, this may be the best we can do. That's the end of the quotation. Now, Rawls' important reflections suggest a way of determining, I think, whether or not a reason is public, and hence can serve as a legitimate basis for the proper exercise of political power, including, I'd like to say, discretionary constructions of CCM in charter cases. Public reasons are, to quote Ronald Den Otter, those that an ideal reasonable dissenter would consider good enough. They're not necessarily the reasons that everyone would prefer under ideal conditions of deliberation, nor are they reasons that every reasonable person in such circumstances would consider particularly strong or ideally worthy of support, but for the fact of reasonable pluralism. Rather, they're reasons, as Rawls would have it, that such persons would all judge to be at the very least not unreasonable, in the sense that those who oppose them could at least understand how reasonable persons could affirm them, in justifying an exercise of political power over everyone. Now, restricting judges to public reasons and public reasoning understood in this way allows, I think, a promising way of warding off the democratic concerns about CCM constructions. Such constructions are, I think, consistent with liberal democratic principles because and insofar as they're products of a process that appeals to reasons to which no reasonable dissenter could object, given the duty of civility, which features in his comprehensive doctrine, as well as the reasonable comprehensive doctrine of every other reasonable member of the liberal democratic community in question, one marked by the fact of reasonable pluralism. Such a dissenter could no more object to a decision based on such a process and such reasons than he could object to a decision properly taken by a properly constituted democratic majoritarian decision procedure with which he fundamentally disagrees. In both cases, our dissenter might prefer that a different decision have been made and perhaps even believe that the decision was mistaken. But in each case, he must be prepared to recognize the legitimacy of the decision actually taken, despite his displeasure, perhaps deep displeasure, with its substance. So appeal to public reasons in justifying the discretionary construction of CCM norms allows, I'm speculating or arguing, each citizen, including those who strongly but reasonably dissent from that development, to take ownership of it nonetheless, to see it as the product of a reasonable process of decision, which appeals to reasons to which he or she could not reasonably object. Now, before moving on, perhaps I should add one additional footnote here. In this paper, I have, for purposes of analysis, treated public reasons as though they were a type or class of reasons distinct from reasons constituted by what I have called CCM, the community's constitutional morality. The former have been characterized, public reasons, as a distinct set of reasons upon which judges might draw in rendering the norms of CCM more determinate or concrete. In truth, I think, the norms of CCM are probably best viewed as a part of public reason, that part which is distinctly linked to the community's authoritatively expressed constitutional commitments, for example, the provisions of its constitutional charter or Bill of Rights. In short, on this picture, all the reasons upon which judges legitimately draw in deciding constitutional cases are instances of public reasons. Viewed in this particular way, the argument of the paper is meant to show that discretionary construction of CCM norms is warranted because and to the extent that judges draw from the same bank of reasons, public reasons, as they do in cases involving the interpretation and application of a CCM norm, but they're not constructing. So, restricting judges to public reasons seems to me, at any rate, to provide a promising way of answering the concerns of those people worried about the democratic legitimacy of charter review. But of course, the critic is not likely to be satisfied with the maneuver I've been trying to take here. Theories of public reason, as we all know, have been subject to many different criticisms, and at least one of these threatens the plausibility of my account. Public reasons, given their shallowness, as it's usually described, and by that is meant they must be shallow or abstract enough to attract the support of all reasonable people, very seldom lead to one and only one reasonable conclusion. They are underdetermined, if you like. On the contrary, different constellations of such reasons often lead to contradictory results. And even when we restrict ourselves to one such constellation of reasons, different weightings of the included reasons can often have much the same result. No apparently unique, correct solution. In short, public reason seems to suffer from the very kind of uncertainty and indeterminacy or underdetermination that was their concern from the start. In most any case involving charter review, any number of public reasons will seem relevant, and it will seem that these can almost always be weighed differently. Reasons of equality, for example, often compete against reasons of liberty in affirmative action cases, or cases involving, say, polygamous marriage. Security of the person sometimes competes with reasons of liberty in cases involving national security and the threat of terrorism. Yet, if there's no uniquely relevant set of public reasons in such cases, or no uniquely correct way of balancing them, even when there can be no uniquely correct answer to the question a judge might try to answer by invoking them. No uniquely correct answer to the question whether, for example, a particular affirmative action program or a practice sanctioning and regulating voluntary euthanasia is publicly justifiable in a particular modern liberal democracy. No way of determining whether, and if so when, habeas corpus can be suspended in times of national emergency. Now, if that's sometimes so, then instructing a court to appeal to public reasons in rendering their discretionary constructions of CCM might appear to be of little help. The court will once again, it seems, be forced sometimes to exercise their discretion, the sovereign prerogative of personal choice. It will be left choosing a reasonable, but at the same time reasonably contestable, balance among the relevant public reasons, and deciding accordingly. In short, we seem to again have taken away the community's right to determine for itself the fundamental norms by which it's governed. So my analysis gives rise to this troubling question. How can one seemingly underdetermined source of guidance, public reason, be at all helpful in dealing with similar problems of underdetermination lurking in a different source of guidance, CCM? Remembering that I'm analytically distinguishing those for purposes of discussion or purposes of argument. In other words, we seem right back where we started, with no means of answering those people worried about the democratic legitimacy of charter review. Now, in answering that particular objection, I want to draw attention to a number of factors. First, it should be stressed that if discretionary choice ends up being necessary in some case when public reasons are invoked, it's only after all the other relevant sources of determinate guidance have been exhausted. In other words, it's only after all the explicit legal decisions and norms and judgments of CCM have been considered and reconciled in an attempt to reach reflective equilibrium, process I describe a bit in the book, and only after the dictates of public reason, such as they are, have been examined and given due measure, that the court may be called on to exercise discretionary judgment. Only then will a court be called on to choose from among options arguably left open to it. But more importantly, if the court makes such a choice and does so responsibly, it will end up choosing an option that everyone, dissenter included, will have to acknowledge to be at the very least not unreasonable, and quite possibly the only one actually consistent with public reasons, with the relevant public reasons. Now that last point, the standing possibility that someone actually might be correct in her belief that she has what turns out to be the uniquely correct balancing of the relevant public reasons in a charter case, or the proper interpretation of CCM norms, despite her inability to convince everyone else of this fact, leads me to a further consideration that I'd like to spend the final part of my paper exploring. The kind of objection I've been considering throughout this paper rests implicitly on an appealing, but ultimately I think misleading picture of charter cases as falling into one of two distinct categories. Those in which it's clear that the relevant norms, whatever they are, CCM norms, public reasons, provide determinate guidance, and those in which it clearly does not. This sort of picture is quite often lurking in the background, I think, in any context in which the possibility of discretionary choice under authoritative standards is in play. Attempts to justify or discredit discretion as a mode of decision-making often assume that we actually know when the limits of determinate guidance end. And then the question is, on what kind of grounds must the decision-maker make a decision? But that, I suggest, is almost never the case. But let's assume for the purposes of argument at this point that a particular case, case 1, clearly falls into the first category I described a moment ago. In other words, it seems clear to all reasonable people that public reason justifies one and only one construction of the relevant norms of CCM. A construction according to which the legislation in dispute is constitutionally invalid. Let's further assume that the arguments advanced here and elsewhere, particularly the book, are sufficient to warrant the courts having the power to construct the norm in such a way as to render the statute constitutionally invalid. There is, I'd like to suggest, no violation of democratic principle in such a case. But now consider a second case, case 2, that falls into the second of my two categories. It seems clear to everyone that public reason is incapable of ruling out all but one competing construction of the relevant CCM norms. It's equally clear that at least one of these, constructions, or sorry, that there is one construction warranting a declaration of constitutionality. And also clear that there's at least one other construction which supports the opposite conclusion. Now, it's very tempting to argue that the court should, in this second case, case 2, be required to defer to the elected legislators and leave the disputed legislation untouched. Since the relevant public reasons seem clearly to have run out in case 2, the court might be said to lack a democratically legitimate warrant to construct the relevant CCM norm as to underwrite a declaration of invalidity. Hence, the court should simply leave matters as they stand. It should, in other words, leave the legislation untouched. There are, however, a number of things to be said in response to this particular line of argument, I think. First, we should once again bear in mind that if it's uncertain whether a norm or set of reasons yields a uniquely correct solution to the relevant question, it doesn't follow that it certainly does not. This no more follows than it follows from the fact that it's uncertain whether Tom is bald, that he certainly has a full head of hair. Hence, the legislation in question might actually, in fact, be invalid, despite the fact that it's not clearly so. Now, suppose one accepted that point. You might then go on to make the following reply, that I've simply ignored the importance of context and associated burdens of proof. Returning to Tom and his questionable head of hair, consider some crazy context in which the burden is on whomever wishes to declare that Tom is bald. And suppose that for some reason or another, that burden dictates that Tom is not to be declared bald or considered bald unless it can be proved, some reasonable level of satisfaction, that he is in fact so. In other words, if we can't conclusively establish to everyone concerned that he's bald, then we have to treat him as if he's not. Might we not say analogous things about judges and the context in which they deal with hard constitutional cases under CCM, or sorry, under charters or bills of rights? Now, for reasons having to do with the archetypal role of judges in a constitutional democracy, one might be tempted to assert that the burden of proof always lies on courts to establish, before issuing a declaration of invalidity, either that the legislation clearly violates a CCM norm and is therefore unconstitutional, or failing this, that public reason clearly warrants one and only one result, that the relevant CCM norm should be extended in such a way as to render it unconstitutional. In other words, it's tempting to argue that the courts really are under obligation to defer to the legislature, unless they can conclusively or decisively show that the relevant constitutional norms have been violated by their enactments. Unless they can demonstrate that the relevant norms have been violated, then the case must, in effect, be treated as one in which it's certain that they have not. Now that latter move is, at least it seems to me at this point, problematic. And I believe so for at least two reasons. Which brings me back to the way in which the original objection was framed. First and foremost is the fact that cases don't come neatly packaged into my two clearly defined categories. Those in which it's clear that the relevant norms and reasons are determinate, that's what I call case one, and those in which they are clearly not, case two. In short, there's almost never a clear borderline between hard and easy cases. Rather, we find what might be called an epistemically uncertain borderline between the two. Putting it another way, it's often epistemically uncertain whether we're faced with what, for want of a better term, I'm going to describe as normative indeterminacy. If so, then there's no escaping the fact that for virtually every case in which the possibility of normative indeterminacy looms large, in other words, virtually every controversial case under a charter or bill of rights, a difficult decision would have to be made as to which of the two categories is in play. And this will be one in which reasonable people could reasonably disagree. One person believing that the relevant norms and or public reasons yield a determinate answer to the relevant question, the other thinking that they don't. In short, the decision that a case does or does not require discretionary choice among CCM constructions or among weighted clusters of public reasons bearing on that choice seems itself to be one upon which reasonable people can reasonably disagree. Should a judge simply place all epistemically uncertain, in other words, controversial, cases into the category of cases in which insufficient normative guidance is to be found, and then simply defer to the legislature's views of its constitutional responsibilities, then someone's reasonable view will be automatically rejected by this practice. More to the point, that person's reasonable view will be rejected in a way that seems to ignore the fact of reasonable pluralism, and does, I think, ultimately do violence to the duty of civility. Someone whose reasonable view is that the case actually falls into the category of normative determinacy and actually does involve a determinate violation of his constitutional rights, or of the only reasonable extension or construction of them, would, I think, every right to complain. He would have every right to complain that the court had abdicated its responsibility to attempt, to the best of its abilities, to hold the legislature to its constitutional responsibilities. He would also have every right to complain that the court had failed to take his constitutional rights seriously, to trade on a phrase familiar to you all. So a simple policy of judicial deference in all cases where it's uncertain whether the relevant CCM norms or public reasons provide fully determinate guidance seems in the end indefensible. Judges can't avoid the hard calls. And that brings me to my final point, which returns us once again to the nature of public reasons and the role they play within a liberal democratic community. The proposals defended in my paper hardly, I think, add up to a recipe for unbridled judicial activism of a sort that's incompatible with the fundamental tenets of democracy. A decision with respect to which a sincere attempt is made to offer justification in terms of CCM, or failing that in terms of a CCM construction justified by way of some reasonable balance of relevant public reasons, should not be viewed as an alien force compelling us to act independently of our convictions. And this is true even when the decision is one with which many of us sharply and deeply disagree. Rather, I think it should be viewed by each and every one of us as an exercise of public power to which none of us, reasonable dissenters included, could object, given our commitment to the duty of civility, a duty of vital importance, I think, in any democratic society marked by the fact of reasonable pluralism. It'll be a decision to which we can all sign on, so to speak. And to repeat, that's not to say that we'll always agree with the decision, including the decision that a discretionary construction of CCM norms was called for. Nor will we always agree with the balance of public reasons on which a court might have relied in justifying the construction it chose to act on. Nor, for that matter, will we all agree with the court's judgment as to the relevant public reasons, thinking perhaps that what the court took to be a public reason is in actual fact a partisan, non-public reason that has no place in constitutional adjudication at all. But insofar as, and to the extent that, the decision is based on a good faith attempt to strike a reasonable balance of what are sincerely taken to be, by the judge in question or the judges in question, the relevant public reasons, and given that that step is taken only after all the other resources have, in the opinion of the court, been exhausted, is, I think, one which all reasonable citizens can accept as, quoting Rawls again, good enough. Each can view the decision as one that allows her to continue to maintain ownership of each and every decision regarding the proper exercise of public power in her democratic community, including, importantly, decisions taken by judges in the exercise of charter review. Thank you.
Thank you very much, Will. It's time to open it up for discussion. I'll try and keep a queue, so if you can raise your hands. But first of all, I have Brian Leiter, please.
Thank you, Will. So you've now hitched your theory of judicial review to the Rawlsian wagon of public reason, which means you inherit all those problems.
I know I do.
So let me ask you about just one of them. We don't, I take it on Rawls's view, owe a duty of civility towards unreasonable views. So what's the criterion of the reasonable and the unreasonable that's supposed to allow us to make this demarcation?
Yeah, that's a very good question, Brian, and I haven't succeeded in marking a distinction, as I think most people have not. I prefer to view public reason. That's why at times I said it's a mode of decision making, in which the key elements are respecting the duty of civility in addressing other individuals with reasons. I take it that an unreasonable view would be one which is not receptive to that kind of reciprocity in the process. But so long as both sides are willing to listen to each other, to compromise to some extent, given the duty of civility, then the reasoning and the reasons invoked are, as, say, Den Otter puts it, and which I think is correct, sufficiently public to warrant acceptability in this context. But I take fully the point that there needs to be some method of distinguishing these two. Otherwise, all reasons are in the hopper, and you've no longer got a basis for decision making that can perhaps be justified. But and that's a tall task. I understand. Like you say, in hitching my wagon, I have brought all the bad stuff along that comes in the wagon, and I'm fully aware of that. And yeah.
I have one question up here, and then Professor Coleman. Aquí.
One position is that, represented by Jeremy Waldron, I think, that that judicial review is in principle incompatible with liberal democracy.
Yes.
Another possibility, represented Dworkin at least, I guess, is that it's required by the principles of liberal democracy. What would you say about a third position, namely that it's a contingent matter? And in some societies, it might be a good thing, in the sense that it might help establish and maintain liberal democracy. For example, in conditions of strong federalism, the United States and the European Union being the prime examples, I think it's a case, in Europe it's certainly the case, that the local constitutional moralities, so to speak, the constitutional moralities of the member states are not identical with the shared constitutional morality. The states have subscribed, by joining to the union, they have subscribed the official morality of the union, but the reasons for their joining might be more of pragmatic nature than principled. And in such a situation, it might be a very good thing to have an independent or quasi-independent court reminding the member states that you have actually subscribed to these principles and you should follow them. But this need not to be as important in other kinds of polities.
No, thank you very much. It's an excellent question. I agree completely that whether judicial review is justified is dependent on the context. And so I view it as a contingent matter. My attempt is to argue that in certain circumstances it can be warranted and can in fact be rendered consistent with democratic principle. That's the burden of this particular paper. Now the EU is an interesting example, one upon which I need to reflect more and which I am going to be reflecting more because Julie Dixon asked me to write a paper on it. And I'm sorry to say that I haven't made much progress on that yet. But that is a particular context in which perhaps judicial review to hold individual communities to their constitutional commitments under EU law might in fact be more warranted than in other contexts. So to that extent, I agree with you completely. But how you reconcile the moralities of the individual member states and the EU is, of course, going to be a tough question. But as I say, it's one which I have to think about more.
Jules Coleman, then Scott Shapiro.
All right. Will, I want to follow up in a fashion Brian's question, but just a fashion. And that is, with the Rawlsian public reason, one of the arguments, as I understood it, was appeal to public reason, and the constraints of public reason are one way of ensuring ownership that's consistent with the liberal democratic ideal.
You're saying that's Rawls' view or my view?
Yours.
My view, yes.
Your view. And ordinary voting and legislation, legislative acts by individuals who are voted into office is another way of doing so, as you indicated at the beginning of the paper. So both of them are sufficient for ownership, but they're very, very different from one another.
Yes, they are.
And what's unclear is that they are related to one another in a way that makes the idea of liberal democracy coherent. That is, they are, one would think, at odds with one another. Because the latter is an enormous set of constraints on the kinds of reasons, and the former is endorsed because it's not. So it's one thing to say that we have many ways of securing ownership. It's another to say that they are both ways of giving expression to the idea of liberal democracy and therefore consistent with it.
Right. Absolutely correct, everything you said. What I would say in response to that is this, that I see the role of charter review, the courts, as holding us to a certain set of commitments that are not necessarily the same as the commitments that, or the interests that are being pursued by the legislative model. And so we can continue to keep ownership of both types of the products of both processes, partly even though they conflict with each other, because there is in my view, a fundamental priority given to the fundamental constitutional commitments, which I see as the role of the judge to, role of the court to attempt to hold us to. So we can maintain ownership of the decisions, even though you have a process, or you have a complex process in which one body is suggesting a decision which in some sense we own, and the other body is issuing a decision which we can again in some sense own. But I'm claiming that the ownership relationship extends most primarily to the fundamental commitments which hold us together as a community, and which we have chosen to adopt when we decide to include a Charter of Rights and put it under the well, not the full control, but the primary responsibility, place it under the primary responsibility of the courts to deal with. Does that help at all, or? So I don't see a fundamental conflict, I guess, between having a process in which certain products come out, and in some sense we own them because they're the product of a process which responds to our input. But then you've got another process which responds to a different set of decisions and commitments to which we can also maintain ownership, and the one takes priority over the other.
Hello? I was just curious how you would respond to this kind of worry, which is a kind of, I think, an American lawyerly kind of worry. So you're trying to justify an actual institution.
Right.
Right? But let's say it were the case that judges weren't particularly good at doing this sort of thing. Right? They either weren't particularly good at figuring out what public reasons are, or, I mean, because apparently even philosophers aren't particularly good at that, because they don't know how to do it yet. Or they were intuitively good at it, it's just that people, being the way that they are, deceive themselves and convince themselves in actual cases that what are their own personal political views are in fact public reasons. Then it would turn out that charter review wouldn't be democratic in the liberal democratic sense. So to what extent is this theory hostage to the way people are, the way institutions in fact are, rather than what it would be nice if they were?
In the sense that I agree that the legitimacy of charter review is a contingent matter, it will depend on some of the factors that you mention. A lot of the case, I think, hinges on the institutional, on the setting of the two institutions and the roles that they serve, and the forces to which they're subject, and so on, and so that courts have, in my view, even though there are abuses, and if the abuses become strong enough, then no longer can we maintain ownership of the decisions. The courts have, in many contexts, and I certainly view it like that in Canada, an ability to deal best with some of these questions, given the kinds of questions that we're asking them to deal with, which I think are not best dealt with in legislatures. So if it turned out that those conditions were not satisfied, then the defense of charter review would fall by the wayside. I don't think there's any question about that. All I'm trying to suggest in the argument, and in the book actually, is that if conditions are right, we have a way of rendering charter review consistent with democratic commitments or democratic principle. One way of that we have if the conditions are right, and I think they are reasonable conditions, or it's reasonable to think that they could obtain, believe that they happen to obtain in Canada, that if those conditions are met, then you've got a process which has many virtues, so they outline in the book, or try to anyway, and which passes muster on the democratic concern. The key element in the theory is that the judges are not imposing their own moral views about such matters, but rather attempting as best they can, in a good faith attempt, to hold the community to its own fundamental commitments, as expressed through what I call its constitutional morality. Now, if it turned out that that despite the fact that in some instances, some societies, that courts are situated in such that they are able to carry out this task in the way that I think they can, but in some other society they can't, then in that other society, judicial review would not, in my view, pass democratic muster. So it is contingent on certain conditions obtaining. But again, the aim is to say that there's nothing in principle undemocratic about charter review if it's practiced under certain conditions and with a particular view in mind of what is going on.
Okay, we have another question up front.
Thank you. Thank you for this new way to put the tension between democracy and judicial review. But I think it seems to me that there is a tension also in your notion of communities' constitutional morality. Because, in my opinion, sometimes the social morality of community is in tension with the ideals of constitutionalism. I mean, it's possible that the social morality of community defends the racial segregation in the schools, or are against or is against the rights of immigrants, for instance. And ideal of constitutionalism perhaps pretends the contrary. And it's not clear to me how this tension is solved in your account, because in my opinion, the tension of the ideal morality, critical morality, and social morality is present even in this notion.
There's no question it is. I'll be the first to admit that a community's constitutional morality, and remember I'm talking about its constitutional morality, not just its social morality, because the constitutional morality is, I think, something distinct from what people happen to believe at some particular point in time, perhaps uncritically, perhaps because of certain forces that are at play in the society at the time, that a community's constitutional morality, despite the non-existence of the factors I just mentioned, might be morally suspect, might not be ideal, might not live up to the ideals of constitutionalism. But the problem is that if we put judges in place to try to enforce these ideals, then we run into the democratic problem. How can you possibly have a system in which judges are appointed essentially as philosopher kings, trying to keep us, in line with ideal morality, ideal constitutional morality? It's very, very difficult to justify that. And I, on that ground, I agree with the critics like Waldron and so on who find the practice problematic. But I still think that there's a role for judicial or charter review, understood in the way that I've done it, because as I see it, the community's constitutional morality is actually a way of the community checking itself. It makes certain fundamental commitments, and it assigns an institution the role of ensuring that it sticks with those commitments, because often we don't. Just as people, we often have fundamental moral commitments, and in particular situations, we don't ourselves follow through with our commitments. And those are cases in which in which we violate in some way our deep-seated moral values and our moments of regret quite often later on. Sometimes we change, of course, our fundamental commitments, and that, of course, is possible on the view that I defend. But nevertheless, sometimes there's cause for regret. I think the same applies at a community level, that there's nothing inconsistent in the idea that a democratic community can entrench certain fundamental moral commitments and say, essentially, we want to make sure that we don't violate those commitments in future. You know, and then there's the standard cases that are often trotted out here. And one way of doing that is to institute charter review. Now, as I say, on that view, I agree with you that the constitutional morality of a society, because it's a socially grounded morality, as you rightly point out, and which is what allows me to make the moves I do in trying to address the democratic criticism, may not be ideal. So you could have a society in which the constitutional morality included things like apartheid, for example. All that means is that judges are not the only ones in the ballgame here. That public debate and change and so on, public debate can bring about change. Legislators have a role in this too, and so on. I'm not trying to rule any of that out. It's just that I think that a healthy practice of judicial review, understood as I have articulated, can be a contributing factor in an enlightened rule of law, which enables us to hold to our commitments. So.
Thank you. I was asked to end the session at 4:30 for a coffee break, but I think we still have time for one more question right here in the middle. Yeah.
Thank you. You've been admirably modest about leaving open exactly what conditions would have to obtain and admitting the sensitivity to conditions. I guess I would like to kind of invite you to maybe speculate a little about how one might look to institutionally implement this particular sort of reasoning in ways more specific than simply the idea of charter review, because Canada has a number of distinct features about how Canada does it, and other countries do as well, that I think might be quite interesting to just hear you speculate through the prism of making sure that the reasons are those that couldn't be rejected by reasonable people. The formula that you'd like there, for example, in two respects, in perhaps respects of composition and procedure. Canada, I know, has something of a quota for making sure that Québécois are represented on the court, which one maybe could see as making sure that particular concerns of reasonable Québécois aren't ignored, aren't sidelined. One might think alternately with procedure that one might perhaps have the voting requirement, since judges vote in blocks often, since change in different kinds of situations, that perhaps sometimes one might think that the way to ensure that reasonable decisions, reasonable dissent isn't ignored is to make sure there can't be dissent, because some sorts of ways of making decisions might require unanimity. I don't know, just throwing out, inviting you to respond to questions of design.
Yeah, well, I agree completely that there are lots and lots of different options that are possible. As you point out, Canada has a particularly, somewhat distinct feature of its constitutional design, which is it's Section 33 of our Charter of Rights, which is often called the override or notwithstanding clause. And for those of you who may not know, what this enables a legislature to do is to essentially get around a constitutional provision as it's been interpreted by the court. And so what the legislature can do after a declaration of invalidity or some other similar declaration by the court with respect to legislation, the legislature can can invoke Section 33 and declare publicly that the offending piece of legislation should remain in effect, notwithstanding the conflict with the charter. And that's, I think the proper way to read that is notwithstanding the conflict with the court's view of the requirements of the Charter of Rights. That's a particularly interesting feature of Canadian Charter Review, which enables, it certainly minimizes the concern over democratic legitimacy because it enables the democratic legislatures to assert their views in certain special cases against the views of the judges when they believe that the courts have erred seriously on some particular matter. So that's one way of dealing with some of these things. There are many more, of course. There are ways of there are systems in which courts have advisory capacity, but not the ability to strike down laws and so on. These are all ways of dealing with some of these problems, which all depend in part on contingent features of a particular society in question. These can all be invoked to mitigate some of the concerns that people have. Now, as far as composition of the court, that's a really tough one, because once you start going down the road of trying to select judges that are representative, then you make the process political, and it's difficult to stop the slide into partisanship, which one sees in some systems, arguably in the United States right now. Now, having said that, I think perhaps one could say that on the conception that I've been defending here in this paper, the primary criterion of a judge should in this context be a commitment to the duty of civility and an awareness of reasonable pluralism and a commitment to that particular view of reasonable disagreement. Now, how you operationalize that, that's a very good question.
Thank you very much. We have to stop here, so please join me in giving Will Waluchow a big round of applause, and thank you guys for coming.
Thank you very much.